everyone, welcome back to Parashuram EduVerse. Today we are starting a brand new series on the Indian Constitution. On this day one, before we study article, fundamental rights, parliament, judiciary or any other topics, we must first understand the preamble because it is often called as soul of the Constitution. Whenever we read the book, we look at its introduction to understand what the author wants us to convey. Similarly, the preamble tells us the vision, ideals, and objectives of the makers of our constitution. The preamble begins with the famous words, "We the people of India." These words indicate that the ultimate source of the power of the India is the people themselves. The preamble declares that the Indian to be a sovereign, socialist, secular, democratic republic and promises justice, liberty, equality and fraternity to all citizens. These values form the foundation of the Indian democracy. In today's section, we will understand the significance of the preamble and why it is considered the guiding philosophy of the constitution. Let's begin our journey into the Indian constitution. For the reference, we are going to study with the A.R. Khan's GKP publications, Indian Constitution Act with the bare acts with the short notes. These are the abbreviations. If we learn that in reading the books, these are the abbreviations mentioned. That, for example, ARTS for article and articles, CL and CLS for clause and clauses, CO constitutional order, INS inserted, P अथवा PP page or pages, PT part, REP reappealed, S or SS section sections, SSCH schedule, SUBs substituted, WEF means with effect from. This is the front page of our constitution preamble. Okay, from now learn the constitutional preamble. We the people of the India having solemnly resolved to constitution India into a sovereign, socialist, secular, democratic republic and to secure all its citizens justice, social, economic and political liberty of a thought, expression, belief, faith and worship, equality of a status and opportunity and to promote among them all fraternity, assuring the dignity of the individual, of the unity and integrity of the nation. In our constitution assembly, these 26 days of November 1749 do hereby adapt, enact and give to ourselves the constitution. First, let us look at notes on the preamble. The preamble embodies the fundamental values of the philosophy on which the Indian constitution is based. The aims and objectives of the constitution are to amplify, reflect in the preamble. Right? The fact that the justice is the liberty, equality are the basic data of the democratic order. Therefore, their inclusion in the preamble is to Indian constitution elucidates the concept of the democratic republic. Thus, the preamble serves two purposes. First, it declares the unequivocal terms that the people of the India are source of the authority under the constitution and that sovereignty resides the people. In this connects two recent judgments of the Supreme Court deserves mention. It is well accepted in the thinkers, philosophers and academicians that is justice, liberty, equality and fraternity included social, economic and political judges. The golden goals is to be the preamble of the constitution is to be achieved. Right? Next is the judiciary decisions. Here there are the two major judicial cases we are going to learn. That is one of is the Berubari case in 1960 and the other one is the Keshwananda Bharati case. Let us move to the first one is in the Berubari case in 1960 the Supreme Court observed that they declared that the preamble was the basis of the understanding of the minds of the framers of the constitution. The preamble helps to legal interpretation of the constitution where language or a word is found to be ambiguous. Nevertheless, Justice Gajendra Gadkar opinion that the preamble was not a part of constitution. Remember, here in the justice of the Gajendra Gadkar opened the preamble was not a part of constitution. This decisive shift in the Sanjan V in the case of Rajasthan Justice, Madalkar highlighted the importance of the preamble by the observing of the preamble had the stamp of deep deliberation that was marked by the precision, and the framers of the constitution attached special significance to it, that the preamble was an epitome on the basis of the features of the constitution. Those basic features were deduced from the concept enshrined in the preamble. In other landmark of the judgment, Gokaknath was a state of Punjab Justice Hidayatullah observed that the preamble provides that the principle in which the government is a function. Here he mentioned that the government is to a function. The preamble is the very soul of the constitution and eternal and unalterable. Here he mentioned that the preamble is the very soul of the constitution and that is eternal and unalterable. Thus, this case mentioned above was the clear departure from the earlier stand of Supreme Court in the Berubari case. The case established no circumstance that the preamble is very much part of the constitution. Here they mentioned that the preamble is not the part of the constitution in the Berubari case. Right? It is the border between Bangladesh and West Bengal. Here it comes. On the basic structure of the constitution, here it changes from in the Keshwananda Bharati in the state of Kerala. Here AIR means All India Report. In 1973, Supreme Court 1461. The Supreme Court held that the preamble was the part of the constitution and it was extreme importance. Remember this point. The Supreme Court held that the preamble was a part of the constitution and it was extreme importance. The constitution should be read and interpreted in the light of the noble vision expressed in the preamble and the provisions of the constitution could be made under Article 368. Constitution could be made under the Article 368 only within the broader contours of the preamble. In other words, that the learned court editorial of the constitution is based on the basic element mentioned in the preamble. If any of these elements are removed, the structure will not survive and it will not be the same constitution or it cannot maintain its identity. Right? Thus, it has been conclusive that the establishment amended in the article that no amendment article in the 66 can be made after the basic feature. So, no amendments in the Article 368 can be made under the basic feature of the articles in the Constitution in the preamble. This was retired by the three other judges, reiterated by the three other judgments in the Supreme Court, which Indira Gandhi V. Raj Narayani, Supreme Court 2299, and the Mir Mills SC Bommai. Secularism, right? Pluralism is the quintessence of the Indian culture and religious tolerance of the hallmark of the Indian secularism. Here it widely believed that all religions are good and efficacious pathways to the perfection of the God realization. Idealism, socialism. Right? Idealism is socialism. The idealism of the socialism, ideals of the socialism found an important place of our constitution. The word socialist read with the article 14 and 16 what made the court that reduce the fundamental right to equal pay for equal work. This again it will read in the article 14 enables the court to declare the pay for equal work, and the court declares a absolute void which false achievement in the socialist goals. The relevant decision in the regards were Excelsior, Atam Prakash of the state of Haryana, Ramdev Vaya Union of India, Nokar Union of India. Here, interpretation of the assembly. In Berubari, in Bharata Chandra Bhavan versus State of Mysore, the Supreme Court observed that the preamble may be substantial helps in determining the ambit of the directive principles of the fundamental rights. Two decisions made to be settled in this context. One is the Keshwananda Bharati in the state of the Kerala and the Dharwad district related daily wages employees associated with the state of Karnataka. Here the interpretation of the preamble. Okay, then social justice, the right to social and economical justice, in which the preamble could be enumerated in the fundamental rights and directive principles of the article 14, 15, subclause 4, 16 and clause 4, 38, 39 and 46 were meant to be making the life of the poor, disadvantaged and disabled citizens of the society meaningful. The concept of the social justice has enabled the courts to uphold legislation to remove the economic inequalities, to protect the interest of the weaker sections of the society, right? And determining the decisions of the living points means res extra. Additional or extra commercial, the doctrine of the res extra commercial means here res means judiciate definition, the matter is already judged, right? The doctrine of the uh, res judicata, that the extra commercial that cannot be extended to prohibit employment of the women in hotels and bars serving liquor. Anuj Garg v. Hotel Association of India. All India Report 208 Supreme Court 663 case number. These are the main features of the Constitution of the India, and the role of the court applies to the writ of the petitions, right? So, friends, that brings us to the end of the day one preamble of the Indian Constitution. Today we learned that the preamble is much more than a simple introduction. It reflects the dreams, aspirations, and the constitutional philosophy of our nation. We discussed how the preamble established the ideas of the justice, liberty, equality, and fraternity, and how these principles guide the functioning of the Indian states. We also saw that the Supreme Court, especially in the landmark Keshwananda Bharati case, 1973, recognized the importance of the preamble or linked it to the basic structure. Remember this important point for UPSC. The preamble is often referred as the sole philosophy and identity of the Constitution. If you understand the preamble properly, many later topics of the polity becomes easier to understand. If you found this session helpful, like the video, share it with the fellow aspirants, subscribe to Parashuram EduVerse and turn on the notification bell. Thank you for watching. Jai Hind.